One of my employees is a poor performer. Am I able to have a conversation with them about leaving the business?
Okay, well, the starting point for any business when faced with a poor performance issue is to first of all consider implementing a capability process, whereby it's a two-way process. You work with the employee to try and improve performance. That said, since the 29th of July of this year, there has been another option for businesses, and that is to engage in what's called pre-termination negotiations. Now, what these are essentially discussions between a business and an employee, in your case, your poor performer, about the possibility of leaving the business on agreed terms with an agreed package, rather than proceeding down, in your case, a capability road, or if the issue is a misconduct issue, down the disciplinary road. And what this change in law does is confirm that evidence of those discussions, those negotiations, will not be admissible in any unfair dismissal claim. This sounds fairly similar to the without prejudice rule, which continues to apply, but it's different in one respect. The protection is there in respect of this new right, even if there isn't an existing dispute. It's not without its limitations, however, and the key limitation is that the protection only applies to unfair dismissal claims. So if, for example, somebody is bringing any other type of claim, breach of contract or discrimination claim, evidence of those discussions will be admissible. So say, for example, if you're wanting to talk to an employee coming up to retirement about leaving the business, or about to talk to somebody due to return from maternity leave, about possibly not returning to the business, and you subsequently face either an age discrimination claim or a sex discrimination claim, then evidence of those discussions would be admissible.
Are there any practical points I should bear in mind when having these conversations?
Yes, the proposals must be put in writing, first of all, in order for them to be legally binding. And you have to clarify the reasons for the proposals in writing, as well as the proposed amount of the payment and timing of the payment. Now, an employee has the right to consider those proposals over a period of 10 days, or a shorter period of time if that can be agreed with the employee. You should also give employees the opportunity to discuss the proposals face to face, and ACAS recommend that they also are given the right to be accompanied. So what you shouldn't be doing is setting everything out in writing or just corresponding by email. Now, the crucial point for employers is they must not engage in improper behaviour. If they do, that will make the discussions, the negotiations admissible in a later unfair dismissal claim. Now, unhelpfully, the ACAS code doesn't actually clarify what is improper behaviour. It says it's a matter for the discretion of each individual employment tribunal. But what is clear is that improper behaviour covers, for example, harassment, bullying, intimidation, or putting undue pressure on the party to agree. And that might include, for example, not giving them the 10 days for consideration.